My name is Arpan Banerjee. I'm a doctoral fellow at the Department of East Asian Studies, University of Delhi, and academic counselor here at IGNOU. So I've been teaching you this paper, Indian Government and Politics, and the code of this paper is BPSC 132. So I welcome you all to today's learning session. So let us begin today's class. So before beginning with the next unit, let us first of all discuss what all we have discussed so far in this paper. So far in this paper, we have discussed the block 1 of this paper, which is pertaining to approaches to study Indian politics. So as part of that, we have in the first two classes discussed the first unit, unit 1 of this paper, which was liberal approach to study Indian politics that we had done in the first class. Then in the last class, we had done the Marxist approach to study Indian politics and the Gandhian approach to study Indian politics. So we are over with this first block, that is approaches to study Indian politics. In today's class, we are going to start with the second block, which is Indian Constitution. So we are going to do Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions, and basic structure doctrine. So this is the second block. And as part of that, we're going to cover two units. That is Unit 4 and Unit 5. Unit 4 is pertaining to basic features of the Indian Constitution, and Unit 5, of course, is going to be the fundamental rights. And in the next class, we shall be doing the directive principles of state policy, which are enshrined in Part 4 of the Constitution. And then we are going to do the fundamental duties, which are enshrined in Part 4A of the Indian Constitution. So let us begin with the Unit 4 of this paper, that is the basic features of the Indian Constitution. So we all know that the Constitution of India is the will of the people of the country, and it sets the broad functional parameters of governance. And this Constitution, it was prepared after lengthy deliberations in the Constituent Assembly, which began on 6 December 1946. And those deliberations, they went on till 26th of November 1949. So if we talk about how the Constituent Assembly was elected, so basically the members of the Constituent Assembly, they were elected through the Provincial Assembly elections of 1946. So the Provincial Assembly elections which took place in 1946, through them, the members of the Constituent Assembly were elected, and almost all the members of the Constituent Assembly were from the Congress Party, because the Muslim League had boycotted the Constituent Assembly because they wanted the separate state of Pakistan. So the precursor to the Indian Constitution was the Government of India Act 1935. So the Government of India Act 1935 was also very significant. It envisaged an all India federation, but that could not come into being because of the princely states objecting to it. And the Government of India 1935, it wanted to create diarchy at the union level. So diarchy was when the subjects of legislation, they were divided into transferred and reserved. So the transferred subjects were the one in which the governor had to act on the advice of the ministers. So diarchy was introduced in 1919 through the Government of India Act 1919, which is also called the Montagu-Chelmsford reforms. So as part of that, diarchy, the system of diarchy was introduced in the provinces. So basically the subjects of legislation, they were divided into, categorized into your transferred and reserved. So the transferred subject were the ones in which the governor of the province had to decide after taking the advice of the ministers, and the ministers were mostly the people of India. So and the reserved subject were the ones which were reserved for the governor's own discretion, and most of the important subjects like finance, defense, they were kept in the reserved list. So that is why diarchy didn't work. But in 1935, Government of India Act 1935, it wanted to create diarchy at the union level. So earlier diarchy was at the provincial level. However, that didn't work out. Yet the Government of India Act 1935 was the Constitution of India till 1949. So, and on 26th January 1950, our constitution came into effect. Although some of the provisions of the constitution, they had already come into effect on 26th November 1949 only. But in full, the constitution came into effect on 26th of January 1950. That is the day we celebrate as the Republic Day. And 26th November is celebrated as the Constitution Day. So the date 26th January was chosen because it was celebrated in pre-independence India as the Purna Swaraj Day. So the 26th January was the day in 1929 when in the Lahore session of the Congress on the banks of the river Ravi, the Purna Swaraj resolution had been adopted. So to commemorate that day, 26th January was chosen as the Republic Day, and that was the day in 1950 when the constitution came into effect. So I have discussed the Government of India Act 1935, which was the precursor of this of our present constitution. And this act, it wanted to create a diarchy, a system of diarchy at the union level. Diarchy is when the subjects of legislation were categorized into transferred and reserved. So right now, if you see, we have the seventh schedule to our constitution, which is enshrined in Article 246. So in the seventh schedule of our constitution, there are three lists in which the subjects of legislation had been enumerated. So the list 1 is called the Union List, which has 98 subjects. The list 2 is the State List, which has 66 subjects, and the last one is the Concurrent List, which has 47 subjects. So on the subjects that are there in the Union List, only the Union Parliament or the Union Government can legislate on those subjects. And the subjects which are there in the State List, the state government, provincial government can legislate on those subjects, and the subjects which are there in the Concurrent List, both union and state governments can legislate on those subjects. So that is how it is. It is given in Article 246, and Article 249, it says that the central government, the Union Parliament, it can legislate for states also if it thinks it is required for national interest. And also the Constitution says that if two or more states, they request the Union Parliament or the Union Government to legislate on their behalf, then also the Union Government has the authority to legislate on subjects which are given in the State List also. And another thing that is there in the Constitution, another provision, is that if there is any contradiction, if there is any conflict between a law that was formulated by the Union Government and a law that was created by the state government, then the union law will always prevail. So that is why we are not a true federation. We are not truly federal. Rather, we are quasi-federal. So we are a federation with a center bias. So the famous British constitutional expert K.C. Weir, he said that India is a quasi-federal state. It is not truly federal. It is a federation with a center bias. So we took this feature from the Constitution of Canada. Since our constitution is inspired from many sources, we took this feature of quasi-federalism from the Constitution of Canada. So how we can see that our country is quasi-federal? So if you see in the Article 3 of the Constitution, it gives the power to the Union Government, to the Union Parliament, to basically alter the area of states, to change the names of state, to merge two states together to create one state, or to bifurcate one state to create multiple states, or to take one part of a given state or province and join it with another province. So the provinces, their identity are not sacrosanct. They have been created for different purposes. For example, through the 7th Amendment Act, which came in 1956, on the recommendations of the State Reorganization Commission or the Fazal Ali Commission, 14 states and 6 union territories were carved out on the basis of on linguistic basis. And then onwards also multiple states came into being on linguistic basis only. For example, the Bombay state was carved out in 1960, was bifurcated into Gujarat and Maharashtra. For example, the United Punjab that was there in 1966, it was trifurcated into Punjab, Haryana, and Himachal Pradesh. Then also we see that in 1972, Meghalaya came into existence from Assam. It was bifurcated. Then in 2000, we see in 1987, Goa was given statehood. Then we see in 2000, not on linguistic basis, but on the basis of regional deprivation and on the basis of development, three states were carved out. For example, that is, Jharkhand was carved out from Bihar, Chhattisgarh was carved out from Madhya Pradesh, and Uttaranchal, which was later renamed to Uttarakhand, was carved out from Uttar Pradesh. So, and then in 2014, we see that Andhra Pradesh was bifurcated to create Telangana and so to create the state of Telangana. So, that is why we see that states, their identity or their existence is not sacrosanct. And Article 3 gives the right to the union only to split one state into two or more, or to join two states together, or to rename those states. So the union government has the power to do that, and Article 2 gives the union government the power to admit new states also. For example, Sikkim was admitted into the union in 1975. So that is why we are a quasi-federal state. There is a federation with a center bias. And also, if there is any conflict between a union law and a state law, then the union law always prevails. And that is why we are not a coming together federation like the United States of America, where the different states, they signed an accord to join the union. Rather, we are a holding together federation. As Dr. B.R. Ambedkar said, that we are a holding together federation. The states, they do not have the right to secede from the union. Right? Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constitution, of the Constituent Assembly, and also the first law minister of the nation, he said it clearly that the union, the states, the provinces, the constituent units, they do not have the right to secede from the union. So that is why we have a holding together federation. So we were talking about the Government of India Act 1935. So not only did it wanted to introduce diarchy at the union level, and it also wanted to create an all India federation, but also the present system of lists that we have of subjects of legislation, which are given in Article 246, the union list, the state list, and the concurrent list, they derive their origin from the Government of India Act 1935 only, and the Federal Court of India, which is the Supreme Court. So Article 135 says that the Federal Court of India shall now be the Supreme Court. So the Supreme Court also has its origin in the Government of India Act 1935. So the Government of India Act 1935 also set up the Federal Court of India, which was later renamed to the Supreme Court of India, although the Supreme Court at that time was not the highest court of appeal. The highest court of appeal was the Privy Council of the Emperor. However, post 1950, post the Constitution, the application of the Constitution, the Supreme Court has now become the highest court of appeal. So the Government of India Act 1935, it also created a bicameral legislature, which we still have. And that is the Rajya Sabha as the upper house and the Lok Sabha as the lower house. Although there was another chamber that was there, that was called the Chamber of Princes, that had members from the princely states. That does not exist anymore. So the Constituent Assembly, it was convened for the purpose of writing the Constitution, and the Constitution, it had to live up to the aspirations of the people who had been exposed to several centuries of justice under British colonialism, and before that under Mughal rule. So the people, they had been exposed to several centuries of injustice, social exploitation and discrimination, colonial dominance, and the makers of the Constitution, they had to take into account the diverse religious, political, and regional sections of the country, and they had to create such a constitution which embodied the interests of these sections. So that is why the motto which the in which with which the constitution making exercise was undertaken was consensus rather than majority principle. So in this, representatives from diverse ideological backgrounds and several of them with a legal background, they worked together. So at the head of the exercise was Dr. Rajendra Prasad, who was a veteran of the freedom movement and who later became the president of India for two successive terms. So there were many other renowned members like Dr. B.R. Ambedkar, who was the chairman of the Constituent Assembly and who has rightly been called the father of the Indian Constitution. Then there was T.T. Krishnamachari, there was Alladi Krishna Swami Iyer, Gopal Swami Iyengar, Shyama Prasad Mukherjee, J.B. Kriplani, Sardar Vallabhbhai Patel, and Pattabi Sitaramaiah. So total 381 members in the Constituent Assembly were there, and they represented various political parties. For example, majority of them belonged to the Congress party. Then there were members from the Communist Party of India, the Praja Party, the Krishak Praja Party, the Scheduled Caste Federation, the non-Congress Sikhs, the Unionist Muslims, and provinces and the princely states were also represented in the assembly. So the different provisions of the constitution, they were extensively debated in the several committees that were formed for this purpose, and on the basis of the deliberations, the drafting committee was constituted on 29 August 1947, and it prepared the draft text of the constitution, and Dr. B.R. Ambedkar was the chairman of the drafting committee. So the final document after making amendments to the draft constitution was signed on 26 November 1949, and 2 months later it came into force. So it is indeed creditable that the members of the Constituent Assembly, they completed the exercise of preparing the constitution within a period of 3 years. So it took other countries many more years to have their first constitution. For example, if we take the example of Pakistan, it took them 9 years to create their first constitution. So they could create their constitution only in 1956. And that constitution also worked for only two years before the dictator Ayub Khan came in and ditched that constitution. And it took them another 14 years. In 1972, they created their next constitution. So we have been very fortunate that the vision of the fathers of our constitution, of the constitution makers, the members of the Constituent Assembly, their vision and their foresight was such that they created such a constitution which is still working for our country. So it is a testimony to the broad vision of the constitution makers that our constitution was never abrogated. There are many countries whose entire constitution was abrogated. For example, Pakistan, and new constitutions were introduced. But in our country, the same constitution has been going on for the last 77 years now, 75 years, you can say. So that is why the Indian constitution was never seriously questioned since the time it came into force. And the changing requirements of the time, they were attended to through affecting amendments to the constitution. So there have been a total of 106 constitutional amendments. The very recent constitutional amendment was pertaining to the Nari Shakti Adhiniyam, which was passed in 2023, which reserved 33% of seats in the Lok Sabha and the state legislative assemblies for the women. So 106 times our constitution has been amended. And however, the essential features of the constitution, they have been retained. So what are some of the essential features of the constitution? So the first essential feature is that the constitution itself is supreme, and the sovereignty of India, it cannot be surrendered or cannot be compromised at any cost. So India is a republic and it cannot be turned into a monarchy. democracy is a way of life. So democracy is a way of life. It is not merely providing for adult universal adult franchise, rather it is a way of life. And secularism and independent judiciary are two pedestals of this democracy. So amendments to the constitution can be made without altering its essentials. So Article 12 of the constitution, it clearly says that any amendment that is made to the constitution that in a way hampers the fundamental rights or affects the fundamental rights in any way, then that amendment to the constitution or that law which has been created, that shall be considered null and void. That is what Article 13 of the constitution clearly says. However, in the post-independent era, there were many conflicts that took place. When the government of India, it tried to implement the directive principles of state policy, especially those given in Article 38 and 39, which talk about creating a welfare state. So basically, Article 39 has a provision which says that the means of production shouldn't be concentrated in a few hands, and the operation of the economy should not be in such a way that it would lead to the common detriment. So to implement all these things, land reforms were necessary. And back then, right to wealth or right to property was a fundamental right, which was enshrined in Article 31. So that is why there were many conflicts that were observed that came into the fore. So the Supreme Court, in many of its judgment, for example, the Supreme Court, in many of its judgments, gave contradictory views regarding the issue of fundamental rights and directive principles. Which is more important? Are the fundamental rights more important, or are the directive principles more important? So that was a question that came into the fore right from 1951 itself, within 1 year of the constitution's being implemented. So within 1 year of the implementation of the constitution, or the working of the constitution, these important questions came into being, that the conflict between fundamental rights and directive principles, that was a major issue. So the Supreme Court, in its judgment, Shankari Prasad versus Union of India, 1951, the Supreme Court said that the fundamental, the constitution, it can be amended to implement the directive principles. The constitution and any part of it can be amended, including the fundamental rights. So that is why we see that the 9th schedule was inserted in the constitution through the First Amendment Act, which included certain anti-zamindari laws, certain land reform laws, especially from Uttar Pradesh. So to protect them from judicial review, to make those laws immune from judicial review, they were inserted in the 9th schedule, which is contained in Article 31A and 31B, which contains the 9th schedule. So there are certain land reforms and anti-zamindari laws which were put in that schedule so that they could be made immune to the judicial review of the judiciary of the Supreme Court or the High Courts. Then we see the famous I.C. Golaknath versus Union of India case of 1967-68. In that case, the Supreme Court, it changed its previous stance. Previously, in Shankari Prasad versus Union of India, the Supreme Court had said that the fundamental rights, they can be amended. The constitution can be amended in any way whatsoever to implement the directive principles of the state policy. However, in I.C. Golaknath case, the Supreme Court, it made a U-turn. It said that it brought in the concept of prospective overruling. So it said that none of the fundamental rights can be amended. So the fundamental right, it made the fundamental rights sacrosanct. So, however, the Union government led by Indira Gandhi, it responded by passing the 24th Amendment Act to the Constitution, and that act said that to implement the directive principles contained in Article 39 and 38, the fundamental rights, they can be amended. So we see that there was this conflict going on between the judiciary and the government regarding fundamental rights and directive principles, and which is more important, the fundamental rights or the directive principles. So the union government was clearly giving primacy to the directive principles. So that is why this conflict was going on. Then in 1973, the Supreme Court gave its landmark judgment, which was the Keshavanand Bharti versus Union of India case. So that case was basically pertaining to Article 26, which is the right of religious institutions to manage their religious affairs. So that it was pertaining to that Article 26. However, Supreme Court in its landmark judgment of Kesavanand Bharti versus Union of India, which was delivered on 24th April 1973, it gave the doctrine of basic structure. It said that the constitution can be amended. Using Article 368, the constitution can be amended, but it gave the doctrine of basic structure. It said that the constitution has a basic structure which cannot be amended at all. So what are the parts of that basic structure that we were discussing? The sovereignty of India, that India is a republic and it cannot be turned into a monarchy, that there shall be parliamentary form of government and not presidential form of government. Secularism has also been said to be a part of the basic structure of the Constitution of India by the Supreme Court in the S.R. Bommai versus Union of India judgment of 1994. Then federalism has also been said to be, although the word federalism is not there in the Constitution, but federalism also the Supreme Court said is a part of the basic structure of the Constitution, and the Supreme Court said this in the S.R. Bommai versus Union of India case of 1994. So the Supreme Court kept on adding features in the list of basic structures. So these are certain basic structures. For example, democracy, universal adult franchise, secularism, independent judiciary. So amendments to the constitution, they can be made, but they cannot hamper the base, or they cannot alter the basic structure of the constitution. So one of the fundamental aspects of basic structure is that India is a sovereign democratic republic, and the preamble to the constitution itself declares that sovereignty rests in the people and it is exercised through the institutions that have been created for that purpose, and the sovereignty of the country cannot be pledged. India cannot be turned into a colony or a dependency of another country. So India shall be a republic always, and it shall adhere to the democratic form of government, so that it cannot be turned into a monarchy also. So these are part of the basic structure of the constitution. And India is a union of states that is given in Article 1. So the union government has the power to create new states. Article 3 gives the union government the power to create new states. And Article 2, it gives the union government the power to admit new states also into the union. For example, Sikkim was admitted in 1975, and I have already discussed how in 1956, 14 states and union territories had been created on the linguistic basis on the recommendations of the Fazal Ali Commission or the States Reorganization Commission through the 7th Amendment Act. And before that, the states or the provinces of India, they were categorized into 4 parts, part A, B, C, D. So that was done away with through the 7th Amendment Act of 1956. And even after that, states were continued to be created. For example, Meghalaya was created in 1972, Goa was created in 1987. Goa was given full statehood in 1987. Then Uttaranchal, which now became Uttarakhand, Jharkhand and Chhattisgarh were created in 2000, and Telangana was created in 2014. So the example of new states that were admitted to the union, Sikkim is an example which was admitted in 1975. Before that, it was a protectorate of India. Then the territories of the Hyderabad Nizam, they were admitted post 1947. Then Puducherry was admitted into the union. Puducherry from the French, Goa and Dadra Nagar Haveli and Daman and Diu were admitted to the union from the Portuguese. And recently, if we talk about bifurcation of states, the state of Jammu and Kashmir, it was bifurcated to create the Union Territory of Ladakh and the Union Territory of Jammu and Kashmir. So our constitution has certain fundamental rights. So Article 14, it gives the right to equality. Article 15, it says that there shall be prohibition of discrimination on the basis of religion, race, color, place of birth. So on the basis of these things, there cannot be any discrimination. And if there is a discrimination on the basis of these things, then the person who has been discriminated can seek legal remedy and can directly approach the Supreme Court, because that person's fundamental rights shall be deemed to have been violated. Then Article 16 is there, equality of opportunity in matters of employment. Article 17 is there in fundamental rights, which abolishes untouchability. Article 18 is there, which says that titles cannot be, a person cannot use titles in front of his name. For example, Rai Bahadur and all, and cannot take titles from any foreign country also without the permission of the government. And the honors that are bestowed upon citizens, for example, Bharat Ratna, Padma Bhushan, Padma Vibhushan, Padma Shri, they also cannot be used before the name. So the abolition of titles. Then Article 19, it contains list of 6 freedoms. For example, freedom of movement, freedom to settle and reside in any place, and then freedom to assemble without arms peacefully, right? Freedom to form associations. All these are given in the Article 19. And there are certain exceptions to these freedoms as well, which were incorporated through the First Amendment Act of 1951 as a response to the Romesh Thapar versus State of Madras case. And also there are provisions for affirmative action or positive discrimination as well, to uplift the vulnerable sections, the weaker sections of the society, that is the SCs, the STs, and the socially and educationally backward classes. So as a response to the Champakam Dorai Rajan versus State of Madras case and the Supreme Court's judgment in that, the Union government, through First Amendment Act, inserted certain provisions in Article 16, which says that the Union government has the right to make special provisions for uplifting and empowering the weaker sections of the society. So that we have already discussed, that India is a union of states, and there are certain fundamental rights which are enshrined in part 3 of the Constitution, and they are guaranteed by the Supreme Court of India. So the fundamental rights, unlike the directive principles of state policy, they are justiciable. So Article 32, which has been called as the cornerstone of the Constitution, the father of Indian Constitution, the chairman of the drafting committee of the Indian Constitution, Dr. B.R. Ambedkar, he said that Article 32 is like the heart of the Constitution. It is the cornerstone of the Constitution. So it basically says that if the fundamental rights of the citizens of India are violated, then they can directly go to the Supreme Court and seek remedy for that. So it includes certain writ jurisdictions of the Supreme Court as well. That is writ of prohibition, writ of mandamus, writ of habeas corpus, writ of mandamus, writ of prohibition, writ of quo warranto, and writ of certiorari. So these are some of the writs that are there for the Supreme Court to directly take cognizance and act. So there are certain provisions of the fundamental rights which are applicable only to the citizens of the country, and there are certain which are applicable to all, including foreigners. For example, Article 20, which gives certain protection in matters of conviction. For example, a person cannot be forced to be a witness against himself or herself. For example, one person cannot be punished for the same crime twice. that is double jeopardy cannot be there. For example, a person who has been convicted for a certain crime shall be punished only according to the law that was in existence at the time of the commitment of the crime. So there shall not be any ex post facto punishment. Then so all these things have been are enumerated in Article 20. So Article 20 is applicable to citizens as well as foreigners. Then we have the very important Article 21, which is right to life and personal liberty. So this is a very important article, and this has been broadened. The scope of this article has been broadened from the Supreme Court from time to time. For example, the Supreme Court, in its landmark judgment of K. Puttaswamy versus Union of India, K.S. Puttaswamy versus Union of India in 2017, it said that right to privacy is also a part of right to life and personal liberty. Then the Supreme Court, in its Subhash Kumar versus State of Bihar judgment, it said that right to a clean air, right to a pollution-free environment is also a part of right to life and personal liberty. The Supreme Court in the Bandhua Mukti Morcha case of 1997 clearly said that right to health is also a part of right to life and personal liberty. And in this, the Supreme Court was inspired from Article 25 of the Universal Declaration of Human Rights of 1948, of which India is also a signatory, which says that it is the duty of the states to ensure good provisions of healthcare to its citizens, and healthcare is a part of human right. So, inspired from this, the Supreme Court in Bandhua Mukti Morcha case of 1997 said that right to health is also a part of the fundamental right to life and personal liberty enshrined in Article 21 of the Constitution. Then the Supreme Court in 1985, Olga Tellis versus Bombay Municipal Corporation case, it said that right to livelihood and right to shelter is also a part of Article 21, that is fundamental right to life and personal liberty. Then the Supreme Court in the working environment is also a right of women. So the right of women to a working environment which is free from sexual harassment is also a part of right to life and personal liberty, that the Supreme Court said in the Vishaka case of 1997. And here also the Supreme Court was inspired from the Universal Declaration of Human Rights. So we can see that then the Supreme Court in the National Legal Services Authority case of 2014 and the Navtej Singh Johar case, the Supreme Court said that the transgenders, they also have a right to life with dignity. So that is was also included as a part of Article 21. So we can see that the right to life and personal liberty is not just right to an animal existence. Right to life is not just right to be just alive and breathing, but the Supreme Court said that right to life, it includes right to life with dignity. Not just animal existence, but right to life, right to a dignified life. So, and then we have Article 21A, which was inserted through the 86th Amendment Act of 2002, which guarantees the right to education to children from the age of 6 to 14 years. And the Supreme Court also had given its judgment in the Mohini Jain versus State of Karnataka case of 1989, which said that education is a fundamental right of the human beings. And in line with that, the Union government, it inserted the Article 21A through the 86th Amendment Act in 2022, and it also made a provision in Article 45 for the compulsory education of children between the age of 6 and 14 years. And in fundamental duties also, Part K was inserted, that is, who is a parent or a guardian to provide opportunities for education to his child, or as the case may be ward, between the age of 6 and 14 years. So we see these are some of the fundamental rights. Article 20, 21 and Article 22, they are applicable to foreigners as well. Then we have Article 23, which prohibits the trafficking of humans and forced labor. Then we have Article 24, which is a fundamental right, which prohibits the employment of children in factories. So These are some of the fundamental rights. Then we have an elaborate set of freedom of articles relating to freedom of religion. For example, Article 25, it contains certain provisions regarding regarding practice and free profession as well as propagation of religion, and that has to be done within the limits of public order, health, and morality. That has been enshrined in Article 25. That is practice, propagation, and free profession of religion. That is also a fundamental right of citizens. So, freedom to profess, practice, and propagate religion within the limits of public order, health, and morality is a fundamental right of citizens. Then we have Article 26, which is pertaining to the fundamental right of religious groups to manage their religious affairs within the limits of public order, health, and morality. Then we have Article 27, which says that no tax shall be collected from any person for practicing their religion. So earlier, the Muslim rulers, they used to collect the jizya tax from the Hindus for practicing their religion. So that is why now the Article 27 has been inserted that no tax shall be collected from any religious group for practicing their religion. Then Article 28 is there, which says that Article 28 says that no religious instruction shall be imparted in government aided institutions, and no one shall be forced to take part in any religious instruction. And Article 29, it gives the right, fundamental right to the linguistic and religious minorities to conserve and preserve their language, script, and culture. Then there is Article 30, which gives the right to religious minorities to administer and establish educational institutions. So all these things are there in the fundamental right, and except during emergency, fundamental rights cannot be suspended. And in the Constitution, Article 359, it says that during emergency, the fundamental rights, they shall be suspended. Article 358 says that provisions of Article 19 shall be suspended during an emergency, which is enforced. Emergency is that is national emergency under Article 352. But even during that national emergency, the provisions of Article 20 and 21 cannot be withheld. This was said through the 44th Amendment, inserted this provision, and it is given in Article 359 of the Constitution. So the 44th Amendment Act, which was brought in by the Janata government in the post-emergency era, it inserted this provision that even during a national emergency, even while a national emergency is in force, provisions of Article 20 and 21 cannot be withheld. So this was in light of the abuses that had taken place during the period of emergency, when the judiciary had also become helpless. And in the SDM Jabalpur versus Shivkant Shukla case, the judiciary had also said that fundamental rights can be suspended during the emergency. However, the judiciary later repented this decision of its. And the 44th Amendment Act, it said that it inserted the clause 1A to Article 359, and it stated that Article 20 and Article 21 cannot be suspended even when a proclamation of emergency is in operation. So we have discussed the right to freedom, and we have discussed Article 20 and 21. And Article 22 basically says that a person cannot be detained without trial. And if a person has been detained, then that person has to be presented before a magistrate within 24 hours of that person's detention. And it has also clauses relating to preventive detention as well. So if a person is detained for more than 3 months, then a certain committee has to be formed to inquire whether that detention is valid or not. So Article 14 we have discussed right to equality and equal treatment before law. Article 15 also we have discussed so far. So there are certain directive principles also in the constitution. So Article 38 and 39, they have these provisions like adequate means of livelihood for all, and distribution of wealth and control over it rather than concentration of the wealth and means of production in the distribution of wealth and means of production and control over the means of wealth and means of production, they should be for the purposes of common good and not common detriment. That is given in Article 39. Then the right to work, education, and public assistance in certain cases of old age, sickness, or handicap is given in Article 41. Then the organization of village panchayats and autonomous functioning of village panchayats, giving them financial and political autonomy. That is also given in the directive principles of state policy, which is enshrined in Part 4 of the Constitution of India. However, the directive principles of state policy, unlike the fundamental rights, are not legally justiciable. So, Article 37, it says that the directive principles, they are to act as a guide for the government to formulate its policy in its policy formulation exercise, but they are not legally justiciable like the fundamental rights. And only the Union Parliament has the right to enact laws to implement the directive principles. So, we have Article 42 as well, just and humane treatment of workers as well as maternity relief. We have Article 39A as well, which talks about free legal aid. This was inserted during the emergency through the 42nd Amendment Act. Then we have Article 43 as well, that is, which is a part of directive principles of state policy, which talks about the minimum living wage, the right to minimum living wage of workers, as well as they should have full enjoyment of leisure and social and cultural opportunities, and the state should take initiatives to organize cottage industries in rural areas either on individual or on cooperative basis. Then Article 43A was inserted through the 42nd Amendment Act of 1976, which said that the workers, they shall be given the opportunity to participate and they shall be made a part of the management of industries. Then we have Article 44, which talks about Uniform Civil Code. Then we have Article 45, which I have already discussed. That is, the state should take initiative to ensure education of children from the age of 6 to 14 years. Then Article 46 is there, which talks about the welfare of the scheduled caste and the scheduled tribe communities and their adequate representation in educational institutions and in public employment. Then we have Article 47, which says that the state has a responsibility to improve the health of the citizens and to raise the level of nutrition, the standards of nutrition, and also to prohibit the consumption of intoxicating substances except for medicinal purposes. Then we have Article 48, which basically says that it is the responsibility of the union, of the state, to organize agriculture and animal husbandry on modern and scientific lines, and also to improve the breed of the cattle as well as to prevent cow slaughter or the slaughter of milch and draught and cattle. And Article 48A is also there, which was inserted through the 42nd Amendment Act of 1976, which talks about the duty of the union to protect and improve the natural environment, including forests, lakes, wildlife, rivers, and to have compassion for all living creatures. Then Article 49 is there, which talks about protecting monuments and places of historical importance. Then Article 50 is there, which is basically separation of executive and the judiciary from the services of the union. And then we have Article 51 also, which basically is a part of directive principles of state policy, which says that it is the duty of the union government to promote respect for international treaty and international treaty obligations in the dealing of organized peoples with one another, to maintain just and honorable relations among nations, and also to promote the resolution of conflicts through arbitration rather than through violent means. So all these things are there in the constitution. Article 16 we have already discussed, and we have just now discussed the directive principles of state policy. All of them we have discussed, which are inspired from the Irish constitution. Then we have certain fundamental duties as well, which were inserted on the recommendations of the Swaran Singh committee in 1976. So the first fundamental duty is to abide by the constitution and respect its ideals and institutions, the national flag and the national anthem. The second one is to cherish and follow the noble ideals which inspired our national struggle for freedom. The third fundamental duty is to uphold and protect the sovereignty, unity, and integrity of India. The fourth one is to defend the country and render national service when called upon to do so. There is a fifth fundamental duty as well, which is to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending linguistic, religious, and sectional or regional diversities, and to renounce practices derogatory to the dignity of women. Then there is a sixth fundamental duty, which is to value and preserve the rich heritage of our composite culture. The seventh fundamental duty is pertaining to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for all living creatures. Then there is the eighth fundamental duty, which is to develop the scientific temper, humanism, and the spirit of inquiry and reform. The ninth fundamental duty is to safeguard public property and abjure violence. The 10th one is to strive for excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavors and achievement. And the 11th fundamental duty is who is a parent or a guardian to provide opportunities for education to his child, or as the case may be, ward, between the age of 6 and 14 years. So these are the 11 fundamental duties. There were initially 10. The 11th one was inserted through the 86th Amendment Act of 2002, which inserted Article 51A, Clause K. So then, of course, the union is also explained, the executive, legislature, and judiciary in the constitution. If you see Part 5, it explains the executive, that is starting from the president, then the vice president, then moving on to the prime minister and the council of ministers, the attorney general, then the members of parliament. All these things, they are explained in detail. So Article 52, it says that there shall be a president of India, and Article 53 says that the president shall be the head of the executive, and shall also be the executive power of the union shall rest in the president, and the president shall also be the supreme commander of the armed forces. Then Article 50, that is Article 53. Then Article 54 and 55, they are regarding the election of the president and the manner of election of the president. Article 57 says that president is eligible for re-election. Article 58 is pertaining to the conditions of the president's office. So all these provisions are there regarding the President of India. Article 60 is pertaining to the oath of the president. Then there is Article 56 pertaining to the term of office of the president. Then Article 61 is regarding the impeachment of the President of India, which has never been done. Then Article 62 says that the election of a new president shall be done before the term of the sitting president expires. Then Article 63 says that there shall be a vice president of India. Article 64 says that the vice president of India shall be the chairman of the Council of States. Article 65 says that in case the president is not able to discharge his or her duties, then the vice president of India shall discharge those duties. Then Article 66 is about the election of the vice president of India. So it says that the electoral college of the which shall elect the vice president of India, it shall consist of elected members of the Lok Sabha and the Rajya Sabha. And this was done through the 11th Amendment Act. Earlier, vice president was elected through a joint sitting of both the houses. The 11th Amendment Act inserted a provision which said that the vice president of India shall be elected by the members of both the houses of the parliament. Then Article 67 talks about term of office of the Vice President, which is to be 5 years. And Article 67 Clause 2 talks about the procedure for removal of the Vice President. That can be done by bringing in a resolution in the Rajya Sabha, and then that resolution, if it is passed in the Rajya Sabha, then it has to be passed by the Lok Sabha as well. So all these provisions are there. Article 69 talks about the oath of the vice president. Then there is Article 70, which is talking about the ancillary powers of the president. The Union Parliament can can give any additional responsibility to the president as well. Then Article 71 is there, which is regarding the disputes concerning the election of the president and the vice president. Then Article 72 is there, which says that extent of the union's power. So all the subjects that are given there in the union list, the union government has the power to legislate on those subjects. Then so that is given in Article 73, the extent of the union parliament's power, the extent of the power of the union. Article 72 basically has the provisions regarding the pardoning power of the President of India. So the President of India can pardon, can commute, can give respite to those people who have been convicted for various offences. Then Article 74, it says that there shall be a Prime Minister of India, there shall be a Council of Ministers headed by the Prime Minister of India, and the President of India shall act on the advice of that Council of Ministers. And what advice and whether on what grounds a certain advice has been rendered, and whether what advice has been rendered to the President, that cannot be called into question in any court of law. That was inserted by the 42nd Amendment. And in Article 75 is also there other provisions as to the Council of Ministers. It says that on the recommendation of the Prime Minister, the President shall administer oath to the other ministers as well, and they shall hold office while during the pleasure of the President. And a very important provision is there, Article 75 Clause 3, which can be called as the cornerstone of India's parliamentary democracy. It says that the Council of Ministers, it shall be collectively responsible to the House of the People, that is the Lok Sabha. So basically, if the Lok Sabha passes a no confidence motion against the Council of Ministers, then the government, it has to resign. The government, it falls. Then we have Article 76, which talks about the Attorney General of India, who is the government's highest law officer. Then we have Article 77, which talks about the contingency powers of the Union. Then we have Article 78, which says that it is the responsibility of the Prime Minister to furnish information to the President regarding the minutes of the meetings of the cabinet and other matters. Then Article 79, it talks about the Parliament of India. Article 80 is basically the fourth schedule, which talks about the composition of the Rajya Sabha, which is a permanent house. Members, they hold membership for a term of 6 years. After every 2 years, 1/3 members there is retire. Then we have Article 81, which talks about the composition of the Lok Sabha. Then we have Article 82, which says that the Lok Sabha, the seats of the Lok Sabha which talks about delimitation of the Lok Sabha after every census. Then we have Article 83 also, which talks about the term of the Lok Sabha, of the members of Parliament, the term of office. Then we have Article 84 in the Constitution as well. Article 85, it talks about the sessions of the Parliament. There shall be 3 sessions in the Parliament. That is the budget session, the monsoon session, and the winter session. So then we have Article 86, which says that the President can send messages to the House and can address the House of the Parliament, both the houses. Then Article 87 says that the President shall address both the houses at the beginning of every session of every year. So at the beginning of every year, that is before the budget session, the President shall address a joint sitting of both the houses. Article 88, it says that the Attorney General and the ministers, they have the right to speak in both the houses, but they cannot vote in both the houses. The ministers, they can only vote in those houses in which they are members of, and they cannot be part of parliamentary committees also. Article 89, it talks about the chairman and deputy chairman of the Rajya Sabha. Article 90 talks says that about the removal of the deputy chairman of the Rajya Sabha. Article 91 says that if the chairman of Rajya Sabha is not available, then the deputy chairman. So thank you so much. Namaste.